Ladies and gentlemen of the jury, these instructions which the court gives you are to govern you in reaching your conclusion on the evidence which has been presented to you in the case. The jury are, of course, the exclusive judges of all questions of fact, and you are also the sole judges of the weight of the evidence and the credibility of the witnesses. As to the principles of law involved, you are to be governed by the instructions of the court. At the outset, I will caution you not to select out of these instructions any single instruction, nor a portion of any instruction alone, but you must consider all of the instructions as a whole and regard each of them in the light of all the evidence in the case. If in these instructions any rule, direction, or idea be stated more than once or in varying ways, no emphasis thereon is intended. The order in which the instructions are given has no significance as to their relative importance. It is my duty to state to you the law applicable to the case, and it is your duty, unaided by any suggestion from me, to pass upon all questions of fact. You will understand that in this charge the court is in no manner expressing any opinion on the weight of the evidence or any part of it, or on the truth or falsity of any witness's testimony, or that any alleged fact in the case is or is not proven. If anything that I have done or said during the trial in ruling on objections or questioning a witness or in any other way seemed to you to so indicate, you should disregard such indication completely. However, your power of judging the effect of evidence is not arbitrary. It is to be exercised with legal discretion and in subordination to the rules of evidence. The court cautions you to distinguish carefully between the facts testified to by the witnesses. The court instructs the jury that the jury must also carefully consider the statements made by counsel in their arguments as to what facts have been proven. You should not consider as evidence any statements made by counsel on either side during the trial unless such statement is made as an admission or stipulation conceding the existence of a fact or facts. Statements or arguments of counsel are not evidence, and neither are statements that may have been made by the court. The defendant comes before you presumed to be innocent. That presumption continues throughout the trial, not only at the beginning of the trial, but throughout all its stages, and even while you, the jury, consider your verdict. It continues throughout the trial, and it is therefore the burden of the state to prove the defendant's guilt beyond a reasonable doubt. In other words, the prosecution has the burden of proving every essential element of each crime beyond a reasonable doubt. That proof may be by direct evidence or by circumstantial evidence or both. Circumstantial evidence is evidence of an individual nature. A man may be convicted on circumstantial evidence alone, and a criminal intent may be inferred by the jury from acts and circumstances which are of such a nature as to prove the defendant's guilt beyond a reasonable doubt. Beyond a reasonable doubt does not mean beyond all doubt or beyond any doubt. It means exactly what it says, beyond a reasonable doubt. A reasonable doubt cannot be a doubt fancied or conjured up in your minds, ladies and gentlemen, in order to escape an unpleasant verdict. It must be an honest doubt arising out of the evidence itself, the kind of doubt that would restrain a reasonable man or woman from acting in a matter of importance to himself or herself. If you have such a doubt as to the guilt of the defendant or as to any of the facts upon which his guilt may depend, it will be your duty to acquit him. The facts and inferences to be drawn from the testimony are for you, the jury. It is only your recollection that counts. In determining what took place, you have to pass upon the credibility of the witnesses. You must pass upon the credibility of all the witnesses, including expert witnesses who gave opinion evidence, and police witnesses whose credibility is to be judged by the same standards as other witnesses. You are to determine the weight of the to be accorded the testimony of each witness. You will consider the interest of the witness in the outcome of the case, his or her apparent intelligence, and his or her ability to observe clearly, and then to relate accurately that which he or she observed. Occasionally there will be conflict in the testimony of several witnesses. You may believe one witness and not believe another witness. In deciding which of the conflicting testimony to believe, you should not necessarily be persuaded by the number of witnesses on either side. You should consider whether the witnesses appeared to be biased or unbiased, whether they were interested or uninterested, and all the other factors which go into the reliability of their testimony.
A little too fast.
Too fast?